Okay, Mr. White, you can hear and see us?
Correct.
Okay, Mr. White, you're not recording this, correct?
I don't want to answer no questions, only through my attorney.
Okay, all right, fair enough. Attorney Whitson and Attorney Malone, I have the Commonwealth's motion, which I just reviewed. Let me hear from the Commonwealth, please.
Thank you, Your Honor. The Commonwealth files this motion essentially to ask the trial court to enforce the SJC Court Rule 119 regarding electric access to the courts, Your Honor. Essentially, by way of brief history, there were two hearings in this former criminal matter, which is now closed. The reference number is 2564979, Your Honor. It's come to the Commonwealth's attention that portions of the defendant's hearings with the court were not only videotaped but posted to social media, Your Honor. More significantly was the January 8th, 2026 civil hearing, Your Honor. The defendant does have a public Instagram account where multiple versions of that hearing were posted. Your Honor's likeness is depicted, as well as Attorney Whitson and members of the trial court here. I'm asking the court to enforce the Supreme Judicial Court Rule 119. Essentially, that indicates that no person shall take photographs, make any recording or transmission by electronic means in any courtroom, hearing room, office chambers, or lobby of a judge or magistrate without prior authorization from the judge or magistrate, then having immediate supervision over such place. My indication, Your Honor, is that Mr. White was not allowed to do so. He was on Zoom in that January 8th hearing. I would suggest to the court that even when people are on Zoom, that is still akin to being in a courtroom for all intents and purposes. When people appear on Zoom, they are often asked to pay attention to court, remove their hat like they are in a courtroom. Zoom is a privilege, I would suggest, Your Honor, and we treat defendants on Zoom like they are here in the courtroom. I also did cite in my motion the trial court administrative order 21-1, which similarly, the court visitors may use their cell phones and other electronic devices in public access areas, but they cannot use cell phones, PED, or camera to take photographs or video in a courtroom anywhere else inside the courthouse, except if they're news media in accordance with the 119 rule, which I just cited, and with permission of the judge.
Is it possible for me to get him on the camera?
Mr. White, you just indicated that you're going to be represented by your attorney. You have a very able attorney here representing your interests. Attorney Whitson's going to speak on your behalf.
I can't see the prosecutor. I'm just trying to say I can't see the prosecutor. That's all I'm saying. Can we move the camera so I can see who's talking? That's all I wanted to say.
All right.
Thanks.
All right, Mr. Clerk. Fair enough. We can move the camera so we can see both Attorney Whitson and Attorney Malone. Okay. Go ahead, Attorney Malone.
Thank you, Your Honor. Your Honor, I would just indicate there, as I indicated, that there are several moments that occurred on that January 8th and prior where the defendant was taping the Zoom hearing of that hearing and posted onto social media. I would also just lodge a general objection, as I'm sure Attorney Whitson will indicate similarly, that this is a closed criminal docket. I would suggest that he is not necessarily entitled to counsel in this moment. I'm simply asking the court to enforce its own trial rule and the SJC rule. I know Attorney Whitson does bring up that the Commonwealth is not technically a party to this case. I'd also suggest, in a similar vein, that CPCS may also not be a party to this case. But this really was a kindling move to have the court address its own trial rule. And this isn't something that particularly the Commonwealth has an interest in, but it does has an interest so far as the defendant, there is significant evidence that he was taping the courtroom for all intents and purposes when he shouldn't have.
Okay, let me turn to Attorney Whitson. Attorney Whitson, I've read your response. Put the standing argument aside. We're here now. There's a court order, a Supreme Judicial Court order that has now been implicated. So let me hear you as to why that order shouldn't be enforced.
Well, okay, first, I don't think the standing order can, or the standing of the Commonwealth can be just ignored. Well, and I'm happy to file an appearance on behalf of Mr. White for that.
So I want you to argue the point. So I'm going to take your appearance here as representing Attorney White. So I want you to argue the merits of the Supreme Judicial Court order that apparently has been implicated in this proceeding?
So first of all, I would suggest that the SJC order, at first blush, has not been violated. Okay. The orders that the rules, or administrative rules that the Commonwealth is citing, neither one I would suggest has actually been violated.
Well, it's not really an administrative rule; it's an actual court order from the Supreme Judicial Court. Would you disagree with that?
I would suggest that it's an administrative rule. Part of the rules, part of the rules, they lay out what the purpose of those are, and that is to and I cite it in my memo, essentially streamline the process of court. In this situation, what the Commonwealth is arguing, or the District Attorney's Office is arguing here, is that the rules were, and I think it's SJC Rule 119 and Trial Court Administrative Rule 21.1. They're both described as rules, but it's a situation where they're both aimed towards recording in court, and each rule lays out the reasons essentially why, so that people aren't recording sexual assault victims, they're not recording witnesses, they're not doing things of that nature to essentially sort of intimidate people that may be involved that are particularly protected. And this is a situation, though, where over Zoom, again, in both of those rules, it talks about recording in the courtroom. Mr. White or whoever is on Zoom are not in the courtroom. Now, certainly, there's certain decorum and things of that nature that
you would agree that if Mr. White, it doesn't have to be Mr. White, if any person were in that courtroom that day that we conducted that hearing, they would not be permitted to record the hearing without prior court approval. You would agree with that?
I would agree with that. If they had prior approval, then I would suggest that I don't see any reason why they wouldn't be allowed, but or why the court would say they can't be allowed. But certainly, if they were in the court physically, there would need to be prior approval according to those rules. But again, Zoom is a very different situation because the court actually controls the cameras. The court controls who is being recorded that entire time, and it's all everything that is being picked up through the Zoom is through the FTR, so everything's being recorded. So it's really not someone recording over Zoom is a very different situation. I think we see this throughout the country. I was just watching on my Instagram feed. There was somebody who was zooming in from their car, and the court notices the judge notices that, and they have an issue with them driving in the car while they're there. During the pandemic, if people may have seen the attorney that had the cat filter on. People record these Zooms all the time, and it gets posted all the time. This isn't like an unusual thing. And I would suggest that the trial court rules are about people recording in the court where the court doesn't have control over those cameras and over what is actually being controlled. Additionally, I would suggest that this is misplaced because there's no evidence whatsoever that Mr. White was the one who actually did the recording. And even the Commonwealth's motion, it talks about a person that Mr. White either recorded or has obtained a recording. So they don't even go so far to say that Mr. White violated the order. So how can they now ask the trial court to enforce this order on him? Additionally, Judge, I would suggest that the trial court orders, what they do suggest is if there was a person in here unauthorized recording in the courtroom, the remedy for that is to expel them from the courtroom or to seize their recording device while they're still in the courtroom. There's nothing in the rules, nothing at all, that suggests that the court has the authority to order the destruction of the recording or to somehow hamstring their First Amendment to prevent them from posting things. And in the last section of my memorandum, Judge, I cite a case, Gene v. Mass State Police. This is a First Circuit. Decision that I think is very much on point, and actually I think goes further than the situation that we have here. In Gene v. Mass State Police, the participant, or in that case the plaintiff, Mary Jean, files a lawsuit against the Mass State Police, the Worcester District Attorney's Office, and others because she was threatened by the Mass State Police with criminal sanctions and legal sanctions because she had posted a surreptitious audio recording of police officers conducting an illegal search in a home. She had obtained that recording from another person. She posted it online. She went to federal court. She sued over the state police's threats against her and won an injunction because ultimately what the First Circuit stated was that she has a First Amendment right to post things online. She didn't violate any laws, and in this case with Mr. White, there's absolutely no allegations that he violated any laws. It's a trial court rules. So in that situation where at that time, although I would say that the law has changed where actually secretly recording the police is perfectly legal now under the First Amendment, but the point being is that the order itself, the request for the order itself would be a violation of Mr. White's First Amendment. He has the absolute right to post or to have anything posted on his Instagram, on his social medias that he'd like. It doesn't matter where that video came from. He has the right to post that. There's no allegations here that he did anything illegal. And again, I would circle back. The Commonwealth's motion, they don't have standing here. This is a situation where the Commonwealth has withdrawn from this case already. They withdrew at the last hearing. They don't have any standing to make this request to the court. They don't have any standing to essentially try to add a civil lawsuit requesting essentially an injunction or temporary restraining order on Mr. White on a closed criminal docket. There's nothing that I've seen from their memorandum that would give them the right to do that. There's just simply no standing for them to sort of interject a civil lawsuit on a closed criminal docket. It baffles me that this is something that's even happening. I've never seen this before in almost 12 years of practice.
Okay.
But
all right. Thank you both. So to the extent that there is a video that was unauthorized, a video recording that was unauthorized of the hearing that was conducted on January 8th, 2026. As to that point, I do find that as the judge who presided over that hearing, no motion was presented or no request was presented to this court to be able to record the proceeding either in person or by Zoom. The only recording that should have been made that day of the hearing was the one that was captured on FTR. To the extent that there was an unauthorized recording that captured the hearing that day, I would find that to be a violation of the SJC Order 1-19, whether it was done in person or if it was unauthorized to be recorded by Zoom, because I find that persons who are appearing by Zoom for their court hearing are deemed present for that hearing. To the extent that there was a recording that was made by Mr. White, I would order that he delete the recording and take it down from any social media website or other website where it could be posted online. I find that to be an inherent use of the court's authority to enforce court orders. Again, the order that the court finds to be at issue here is SJC Order 1-19. Mr. White wishes to take an appeal of this issue, which he has every right to do. He can do that. That's the court's order. Okay? Thank you.
No, it's not.
Okay. Thank you, Mr. White.
Thanks.
That's some bullshit.